Welcome to Clause 8. I'm Eli Mazur, and today we're lucky to be joined by Tariq Hafiz.
Thank you, Eli.
Tariq arguably has one of the hardest jobs at the USPTO, if not all of government. He's the director of Technology Center 3600, overseeing the business method art units that examine patent applications related to everything from finance to shipping and transportation. It has never really been easy to convince an examiner in one of those business method art units to grant the patent application, but it's become considerably harder after Alice and Director Hafiz was brought in and started really giving examiners the confidence to properly apply the law and grant patents again. So hopefully we'll get into all of that. Thank you so much for joining us.
You're welcome, Eli, and be happy to be here.
I thought it'd be interesting to really talk about how you became the director. You started out as an examiner. Do you remember how you ended up applying to work at the USPTO, how you became interested in the field?
Yeah, it's really interesting, right? After I graduated from college, I was working for a defense contractor, Computer Sciences Corporation. And one of the things I noticed is during that time, their whole life was dependent on defense contracts. And the project that I was on, every year, they were laying off folks. So the size of my group was dropping, by the tens. It was over 200 people in my project area. And after 3 years there, it was down to 15. And I didn't know how I survived there. It was scaring the heck out of me. It's like, I need to get a stable job. And I started looking at government jobs, and I ran across USPTO and interviewed on a Friday and a Saturday. Then I got an offer, and ever since I've been here.
When you first joined, did you have any long-term goals?
That's a good question. At the beginning, I really didn't know what I was getting into. I really hadn't had much experience with patents or patent law. And it's like, it was a government job. That's the only thing that I knew. Then after I started working, I found it to be very interesting, and I really excelled at it. I loved it. I loved being a patent examiner. And I moved up to the ranks of a primary patent examiner. I was making my own decisions. I was training folks. Then I became a supervisory patent examiner. Again, one of the things that I've done is I try to be innovative, and I tried a lot of neat, innovative things within my units, and I enjoyed it. And I felt like I could really make a difference if I became a group director.
Everybody thinks one of the perks really of being an examiner, once you become more experienced, a primary examiner, you get to work independently. You get to make your own decisions. You don't have to worry about what everybody else is really doing. Why did you really decide to take on that additional responsibility of being a supervisor, then a director later on?
Well, first of all, I really love the job of a patent examiner, and I found it to be super interesting. And I know there are some folks that were struggling. And as training examiners, when I was a primary, I knew that I could have a bigger impact as a supervisor. I really wanted to make a difference, and I felt like I could contribute more to the agency as a supervisor than I could as an examiner. As an examiner, I was only helping a few folks that I was training or the folks that were coming to me. As a supervisor, I had the ability of training or helping 13 to 15 examiners. That's why I joined the PTO, wanted to help.
That's great. And I think everybody who does patent prosecution is familiar with what an examiner is and what a supervisor is. Can you tell us a little bit about what really is the role of a technology center director?
Yeah, it's just another level up. As supervisors oversee examiners, and then they actually are the signing official for junior examiners. They sign grants of patents. As a director, I oversee the work of supervisory patent examiners to make sure that they're doing what they should be doing. I set the tone and direction for the organization that I'm in charge of, for example, business methods. And I try to actually develop and build confidence from supervisors as well as examiners to make the decisions.
Is your interaction with the supervisors kind of similar the way that supervisors to examiners? Like there's some supervisors who really operate independently while there are others who you're more involved in helping, I guess?
Absolutely. You have, when you have large number of folks in any organization, you're going to have different levels of interaction. So there are some supervisors who are more hands-on. They'll actually sit down with the patent examiners, do the search, show them how to search, and actually, really get into the nuts and bolts of examining. There are other supervisors who are a little bit more hands-off. They let the examiners actually develop themselves and just be available for Q&A. So everybody has a different comfort level on how they want to manage their units. At the end of the day, all the supervisors are responsible for results that I expect from them. I give them the freedom and flexibility to manage how they want to manage, as long as they're producing results, which is quality, productivity, timeliness, and everything else that goes with this job.
Yeah, and I guess it makes me think of two issues that I'm curious about. How does the PTO, identify what examiners will be successful supervisors?
It's not just the USPTO, it's just any organization. Usually, when you're promoting within the ranks, highest performing employees get promoted. whether you're in a private sector or a public sector. So our highest performing patent examiners tend to make really good supervisors. Usually people lead by example. If you're an average performing examiner, you're going to be an average supervisor. If you're a high performing examiner, you're likely to be a high performing supervisor. Not to say that it works every single time. We have over 600 supervisors. There's some that aren't as productive as we would like them to be. But again, when you have a group that size, you are going to get that bell curve. You're going to get a few that are stars, large group that's in the middle, and we're going to have a few that are not stars.
That makes sense. Another thing I'm curious about is what are the common issues that you see?
So the common traits that I look for, we have about 30 technology center directors at PTO. So everybody has a few different things that they think are great characteristics of a supervisor. For me, one of the things I'm looking for is somebody who actually has a good work product that they can actually, lead by example, and good quality, good productivity, and they have some leadership skills. They're like actual leaders in developing junior examiners, are outgoing, have good communication skills, and other things we can develop. A lot of the management skills we can develop, right? I just want them to be, somebody who can make decisions, make good decisions.
Sure. And I guess once they transition into being a supervisor, are there certain issues that they currently run into? Like, are some of them too hands-off? Are some of them give too much deference to their examiners? Anything like that you see? Or
it varies. And one of the things that I do that I'm really proud of is I actually have one-on-one meetings with all of my supervisors every month. We sit down, we discuss each examiners that they supervise, if there's any issues going on with them, whether it's performance, whether it's actual conduct issue, what are some of the things that we can do to help these examiners and what we can do to help them. So I want examiners to grow as well as supervisors. So, I usually know up front if there's some issues that's going on with them. I have all types of reports that I look at to see how well their unit is performing in comparison to the other units, and we're really on top of it.
So going back to what I said in the beginning, after Alice came out, some people thought really that maybe all the business method art units would get shut down. They really stopped granting patents, it seems, statistically. And then you are asked at that point to become the director for those business method art units. Can you tell us what was your reaction to that at first? What did you think was your biggest challenge going to be when you first took on that role?
Yeah, two answers. One, my reaction actually was I was a little excited, and that's a strange thing to say for somebody who wants to go into business methods, is because I was a supervisor in business methods for a long time, and it was more like going back home. That was really like my first reaction. My second reaction was I knew what the culture was. I knew that Alice's decision had been handed down, and we were not issuing as many patents, and I wanted to find out why, right? I wanted to find out, is it truly a one-on-one issue? Is it a priority issue? So I came and I started looking at what the issues were, and I found that it was a combination. There are some applications that were filed prior to Alice that are fairly weakly written and that couldn't pass a one-on-one test, but there are others that were very good, and we can move along. And one of the challenges I faced was building the confidence of patent examiners as well as supervisors to letting them know that after we've done our due diligence in terms of analyzing on 101, 112, and prior art, it's okay to allow. As long as you do your analysis, don't be afraid of stretching a rejection. If it's in the gray area, we focused on prior art, let it go on the 101. And then, if we can't find prior art, we issue it. That actually relieved a lot of folks. I went to every single art unit and gave the same message to the examiners. SPEEs heard it multiple times. And what that led to is in my first year, we made tremendous progress. We doubled the allowance rate within the first year. In the second year, I think we doubled it again. We're just moving towards pre-Alice metrics in a lot of areas. A lot of areas people just don't see. They're just focused on the allowance rate. Right. But there are other things that I'm working on besides the allowance rate. Yeah. I'm focusing on compact prosecution. I'm focusing on search. I'm focusing on examiners actually doing the right thing right away. Don't piecemeal examine. Don't just give a 101 because it's easy. Do your 101, do your 112 analysis, and do a thorough search and make sure you address the priority issues upfront.
That makes sense. Is there anything that you learned by managing art units outside of business methods that you brought back when you came back home to the business method art units? Is there anything in the way that those other art units approach things?
Actually, not as much as you would think, right? The philosophy is really similar. Whether you're in business methods or whether you're in electrical arts or mechanical arts or chemical arts, we all have the same MPP we follow. We all have to follow the same law. And training is fairly similar. The only thing that's a little different is how we search. And in business methods, the focus is a little bit more on 101 because just about every single case could potentially have a 101. Very few arts in the office have that. A lot of the arts will see a 101 maybe once or twice every week. And in this area, every single day, every application the examiner picks up could potentially be a 101. So that's why it's different. But how we examine or how we approach a case is pretty similar across the office.
As I was preparing for this, I saw that, at least on the USPTO website, it seems that the business method art units were consolidated. So before, let's say you had one business method art unit that dealt with electronic voting, healthcare, and so forth. It seems now that each art unit deals with a variety of technologies. Is my understanding correct?
No, actually, it isn't, right? So what we have is 9 core areas in business methods. And each area has several to handful art units. For example, our finance area has 8 art units currently. Our advertising art unit has 5 art units. So all the supervisors are focused in those technologies. So advertising art units actually do advertising. So what had happened was business method is growing. It has been growing for the last 20 years. Currently, we have 34 supervisors. I can't say we have 34 art units because we just don't have enough numbers in 3600. So we have some supervisors who share an art unit. There's 2 to 3 art units combined under one number. Okay. So we have 3 supervisors leading art unit. For example, 3685 has 3 supervisors.
And is there more supervisors because the patent office recognizes there's more assistance that's necessary?
Well, there's more supervisors because what we do is our goal typically is each supervisor can manage about 13 folks.
Okay.
13 to 14 folks. So right now in business methods, we have 450 examiners. So you divide that by 13 and you get roughly around 30 plus supervisors. Okay. As we continue to grow, we're hiring about 75 to 80 examiners this year. That means we're going to be adding like 4 to 5 more supervisors. So the more supervisors means we just have more examiners, and our ratio across the office is similar, whether you're in business methods or any other art unit.
As you might know, fairly or unfairly, and I think you touched upon it, there's a perception that if you file a patent application, it gets assigned to one of those business method art units. You're either not going to get a patent or it's going to be a very hard journey. In fact, me and you were discussing before this interview started, there's even these tools out there that help patent practitioners figure out how to avoid those business method art units. First, what do you think of that perception? And second, does that impact in any way how the business method art units need to change or operate in the future?
Actually, it really doesn't. The best advice I can give folks is, first of all, you want a really strong patent. And one of the things, since I've been in business methods as a director, I've noticed is our examiners are very good. They really understand the law. They really understand 101. And if you want the strongest possible patent, who cares where it goes? You want to focus on, you want to get the patent that you can defend. You don't want a patent just because it's got a patent number on it and it's a trophy, right? Depending on your goals for a patent, if you really want a strong patent, you want it to be examined in the best way possible. So we really don't care where you apply or how you modify it. If there are tools out there that tries to change the assignment from business methods to databases or some other technology center, more power to you. But ideally, you want the right examination. And one of the things that we're doing at business methods is we're trying to focus on compact prosecution. In fact, if I was an applicant, I think I have a better chance of getting a patent in business methods than anywhere else, because you want examiners who understand the law, understand 101, and are really good searchers.
Does a patent office kind of do their own analysis in terms of, here we have 2 patents get assigned to 2 different art units, but really they're the underlying technology and the claims are the same, I guess they're similar. Do you guys take a look at whether they're treated similarly or not between the different art units?
So what we do is when the patent application comes in, there's a process. We have actually a mechanism where how we direct the cases. It's really based on the technology that's being specialized in a particular art unit. So if you file a patent application in the finance area, it's going to go to the business methods finance. If you file an application in the database area, it will go to 2100. It doesn't matter whether finance or 2100 has too many patent applications or too few. Applications are routed based on technology, not necessarily the inventory of those art units. So what we do is we shift resources as our inventory changes. Yeah. So if you have too many applications in business methods, well, we need to hire more. If we have too few applications in another area, we're going to see if we can move some examiners from those areas into areas that have a bigger backlog.
That makes sense. I guess there's some, if they look at similar technologies, get assigned to different art units and they think they're treated differently.
Yeah, there's a lot of legends out there on how we do things at the PTO. Internally, our process, first of all, is fairly transparent, and we can show you how we do things in terms of how we route applications from the initial filing and how they're distributed across the technology centers and how they're assigned to examiners. Our goal really is to work on our oldest applications and move them first in, first out basis. But there are assigned based on the specialty of that particular art unit and nothing else.
Before we dive into some specific issue, I really wanted to get a sense of how policy is formulated and implemented at the USPTO from your perspective as a USPTO director.
For example,
when there's some significant 101 decision, you see a USPTO issues a memorandum signed by the Deputy Commissioner of Patent Examination Policy to the examining corps. What kind of input, for example, do you have as somebody who's going to be the most responsible for making sure it gets properly implemented before such a memorandum comes out?
So typically what happens is when a court decision comes out, usually our policy shop, like Deputy Commissioner for Policy, they will actually look at it and evaluate it. And they actually do get guidance from various stakeholders, including the group directors. They will actually, not just me specifically, but they'll share with the group directors saying, hey, this is what we're going to come out, and we have opportunity to provide some input. So it is like in any policy that comes out, most of the stakeholders within the organization has some input.
Going back to that, obviously every few years or every 4 to 8 years at least, there's a new USPTO director. How does that really impact your day-to-day job, if at all?
So typically, usually the new USPTO director, they have some priorities and we try to implement any priorities that they want. But day-to-day examination doesn't really change from one director to another, right? Our policies and our laws are still there. Our examiners are still doing the exact same thing. Anything that's new, that's implemented, that's just based on whatever priorities that they want.
And going back to that example where the memorandum comes out, once he's Deputy Commissioner for Patent Examination Policy, it's a bit of a mouthful, but once he sends out, the draft of that memorandum, is a plan made at that point about what the implementation will be like what kind of training will be required? How does that process work?
I think a lot of those things work in parallel. We know that the memo is going to be coming out and we plan for some training depending on what the memorandum is going to be, but we want to make sure that examiners get the memorandum as soon as possible and then we provide training right afterwards.
And is most training, and you obviously examiners do a lot of training in terms of they meet and you guys have these PowerPoints that you release that they go through. But is there more, informal implementation? Like, for example, a new memorandum comes out. Do you kind of send a message to your supervisors in an informal way? This is how examination should change on a practical level?
So when the memorandum goes out, actually there's training for supervisors, there's training for the folks who are going to provide training to examiners as well, and then there's a training for examiners. And there's different formats, right? Sometimes it's PowerPoint, sometimes a workshop level, sometimes it could be just a chat. And then after the training, some of the experts who've been trained on this topic will have smaller meetings. We have quality enhancement meetings, and you could talk about that subject matter. We can have a lot of one-on-one discussions with examiners who need additional help. So there's a lot of resources available to examiners at the technology center level to get more help on that particular topic. For example, for Berkheimer, memorandum came out, provide training. We have experts, quality assurance specialists. We have supervisors who actually provide training as well. And then they do actually quality enhancement meetings where examiners bring cases and they can talk about a particular topic and get more insight on that.
I guess another question is, sometimes it maybe seems from a practitioner's standpoint that there's a lag between a new memorandum that you see on the website to the time that an examiner is actually applying it. How do you avoid that issue?
So remember, we have over 8,000 examiners.
Yeah.
So think about providing training to 8,000 examiners.
Right.
It's a challenge, right? We don't want to give trainings to 8,000 examiners in like that within an hour so that we meet that timely requirement. What happens is we want to make sure that our training is actually productive and there is actual comprehension on the material from the examiners. So it takes time to actually schedule and get everybody trained so they learn it. And we want to do it in smaller groups. Some trainings we could do it in larger groups. It still takes a long time for 8,000 examiners because we want to provide live training as well as through video conferencing. And think about a large conference room. How many people does that hold? And think about 8,000 examiners and how many sessions we need to have. So we have a large number of sessions and it takes time. And that's why there's lag.
Is there any kind of process that you use to check or get a sense if examiners are actually applying the latest guidance or memorandum in the way that it was intended? Is it any kind of spot checking, or how do you get a sense of that?
Yeah, there actually is, right? So junior examiners' work is reviewed by other primaries or a supervisor. And then supervisors actually review the work of primary examiners. Not every single case, but they'll do spot checks quarterly. And we have Office of Patent Quality Assurance that reviews work of all of our examiners randomly. We have decisions from PTAB. So we have various mechanisms where we're getting feedback on whether or not the examiners are applying our training. And if they're not, we're able to actually, provide reinforcement training or provide feedback. So that's being done day to day in every art unit. Supervisors overseeing 13 to 14 folks, like I was telling you earlier, half of them may be junior. So that supervisor has a pulse of that art unit knowing, hey, they don't understand this memorandum or they're not applying this memorandum. I, A, either need to provide additional training or B, really need to reinforce something. And they have resources available to them. They can ask a quality assurance specialist, come provide training for their art unit on this particular topic because the examiner's not getting it.
Maybe I'm being a little Pollyannish, but is there an opportunity for a supervisor to go back to, for example, the director and say, well, this memorandum is really unworkable. There's no way you can expect examiners to apply it. Is there any kind of that kind of mechanism for that kind of feedback?
So what we'll do is, like, if somebody did come to me with that, I really haven't seen it yet, but if they did come to me, and my question would be, what specifically is not workable? And I would try to get to the bottom of it. And once I've identified what the issues are, we'll try to see what we could do to fix it. Maybe we need to actually clarify our training or clarify the memo. And everybody's really open to feedback. If there's something that doesn't make sense, we want to fix it. Yeah, and we'll definitely do that, whether it's memorandum, whether it's training, whatever it may be. We all make mistakes, and if we did make a mistake and we need to fix, that's okay. We will fix it.
We'll dive a little more into these one-on-one issues in a moment. But before I forget, I guess there's a bit of a mystery that maybe you can help resolve. A lot of times when you talk to examiners, they say, well, especially when there's a one-on-one rejection, they say, well, I'll have to run it by the one-on-one panel. Officially, the PTO, from what I understand, said there's no such things as one-on-one panels. What are examiners referring to when they say that?
Well, I love that question. You know why? Because I've heard it so many times already. It's a great question. First of all, there really is not a one-on-one panel. And even if there was, ultimately, the decision on any application rests with the primary examiner. We have that on our website, on Business Methods website, right? So primary examiner is the decision maker. So even if they go to a one-on-one panel, although it doesn't exist, if it did exist, and one-on-one panel said, you can't issue it, right? Primary examiner can say, you know what? I disagree with you. I'm going to issue it anyway. And they have every right to do that. And nothing stops them from doing that. Primary examiner is the ultimate decision maker on eligibility, allowability. So junior examiners, their primary examiner is whoever they report to. It could be another primary examiner or their supervisor, because supervisor is also a primary examiner. So the ultimate decision rests with the primary examiners, whether or not there's a one-on-one panel exists. So from your practitioner's point of view, any primary examiner that tells you that one-on-one panel won't allow them, tell them, aren't you the ultimate decision maker? You can say that, right? Yeah. And so regardless of what private one-on-one panel tells them, if there was such a thing, all right, say, hey, you're the ultimate decision maker. They're only a recommending body anyway.
Yeah.
Right? So if you think it's allowable, use your pen or keyboard nowadays.
But what are they referring to? Is there a group of experts within the art units or what?
So this is something that's existed throughout time at the PTO that I've been here since 1992, right? There's always technical experts as well as legal experts in every technology center.
Okay.
If examiners choose to go to them for advice, they can. If they feel like they know it, they don't have to. So our quality assurance specialists tend to be usually experts on the law, and we have technical experts are usually sometimes other examiners or supervisors. So you go to the person that's going to help you the most, and we're not going to stop that from anyone. Hey, if you need help from a technology expert, go to them, get some help. If you need help from a legal expert, go to them, get some help. But nothing stops the primary examiner from making a decision on eligibility or patentability.
We'll get to this more as well, but I thought this might be a good time to ask. You talked about how the primary examiner is the ultimate decision maker, and really the supervisors spend most of their time with the junior examiners.
True.
I guess, what do you think is the role of a supervisory examiner in terms of managing experienced primary examiners? Let's say they have a disagreement. Should they try to persuade the primary examiner to change their mind, or really allow that primary examiner to operate independently?
So supervisory patent examiner has a role of oversight. So if they see a primary examiner that's not doing something that they should, there's a lot of performance mechanisms they could use as a manager, or they could, like you're saying, persuade them saying, hey, your position on this point is not consistent with our training or our guidance. You may want to do something else. And tell you the truth, 99 out of 100 times, most primaries are receptive to feedback from their supervisor or quality assurance specialist or others, right? If they see something that they're making a mistake on, they want to correct it. Yeah, there's a time maybe one or two primary examiners may say, you know what, I disagree with you, and they can explain why. But ultimately, the supervisor's role of oversight, and if they feel like they're doing something improper and primary examiner does not want to change it, supervisor always has the authority to move that case to another person if they want.
In terms of a supervisor, should a supervisor ever be saying, well, he's a primary, he can do what he wants, or...
Well, some supervisors may want to say that, but ultimately, again, it goes to ownership.
Yeah.
Supervisor is really responsible for that art unit. So they need to actually be owning up to the decisions that are made within that art unit. So if there's a primary examiner that's not doing what they should be, that supervisor's responsibility to correct the behavior.
That makes sense. We'll come back to this because I think this is the most interesting stuff from to really get your perspective on. But I wanted to really take a step back. Let's say you're an innovator in the financial field and you hear they're not granting patents anymore for finance, for example. What would you tell that innovator in terms of deciding whether they actually have an innovation that's worthy of overcoming 101?
Get a lawyer. So first of all, it's so funny that you said that we're not issuing patents in the finance area. In business methods here, since I've been here, we are issuing patents in the finance area.
That wrong perception. I know.
So that's just a small talk. So what it is I think this is advice that goes to all innovators, whether it's in the finance area, computer technology, or mechanical device. We have a really great website. They should visit our website first, right? Just learn about patents if you don't know much about patents, and see what type of invention you have. And if you feel like you have something that's worthwhile, definitely, I wasn't kidding, they may want to consult a patent attorney, right? They can definitely do it pro se. They can definitely do it themselves, and we have resources available to them. And I think there might be additional resources if they go to our website that could help them get started. But they definitely don't want to make independent decisions, even though they may think that, they don't issue finance patents anymore, so I'm just going to give up. Hey, don't give up. Yeah. Do some research. Do research on our website. Go on the internet. Do some research on patents in your field. Consult folks. Consult experts in the field. Like I said, lawyers, consult a lawyer if you want.
Is there any kind of high-level guidance that you can give to somebody, let's say a stockbroker? There's some innovation in their field about whether, this is just a purely business idea that you can get a patent on versus something that would really overcome that 101 hurdle.
For them to make that assertion or determination, they would have to know 101 policy. And chances are the independent inventors or a stockbroker or someone else on the street usually is probably not versed in our 101 policy or 101 guidance versus an attorney who practices it daily. They probably know it better.
I agree. So going back to what we're talking about examiners, I looked at your history. A lot of initiatives that you were involved with were really about improving a lot of the interview programs that the USPTO has. I guess before we dive into those, can you just tell us really about how do you view the relationship between the examiner and the practitioner, and why do you think interviews are important?
So my personal feeling is I think the relationship between the practitioner and examiner is really a collaborative relationship. I think both of us are trying to get a same goal. If I'm an examiner, my goal is how can I help this applicant get a patent? And the way I want to do is I want to make sure that patent is strong and it's valid. And I want to do the best search that I can and best analysis in terms of 112 or 101, ultimately, right? And when I determine that something is, not in line with 101 or 112 or prior art, I want to point it out clearly in the office action. And when I have an interview, I want to be able to explain my position on where I'm coming from. And from the practitioner's point of view, I want practitioner to tell me where I'm wrong. Why is my analysis off? Maybe I can provide insight to the practitioner and vice versa. If I'm reading your claims in a certain way, maybe the practitioner needs to amend those claims so that they're more clear. Or if I'm applying the art in a certain way, maybe practitioner needs to tell me that, hey, the prior art that I'm applying is different from the invention because, explain it in technical terms. Remember, patent examiners are engineers. They understand engineering. Speaking in technical terms will go a long way. Although most practitioners are attorneys, they're trying to get this legal protection of a technology. So we want to speak in technical terms, and I think you'll get it further along.
And the best way to do that is through an interview, I think, as you're suggesting. But what do you think is the most effective way for a practitioner to handle an interview in terms of, should they just use that opportunity to tell the high-level story about what the innovation is? Should they really just, you have a limited time, dive into those specific issues? What do you think is really the best approach?
So from what I've found to be the most effective approach really is, first of all, like you mentioned, examiners have a limited amount of time. So high-level stories may or may not help, but you want to really describe the invention in technical terms. Point out, hey, I invented this widget that does X, Y, and Z. And the thing that's special about this widget is because it uses this particular circuit or whatever it may be, right? So whatever your novelty is, then get to that point and explain how the reference that the examiner has applied is nothing like it. And, if you do that, then examiner can understand it's like, oh, I see what you're saying. Then they can look at the claim saying, okay, you were saying your invention was this, but where is it in the claims? Then you show them in the claims. You're going to have a productive interview. And a lot of times what you'll find is when you go to your claims, some of those features that you talked about may not be there. And that would help the examiner to resolve. They really want to help you. I think most examiners want to help you. They want to work with you, try to resolve issues and issue a patent. Are there some people who don't? Of course. We have 8,000 examiners. You're going to have some difficult examiners. Just like some practitioners, we have some difficult practitioners.
Yeah, I think most examiners definitely want to work with you, but it's the ones that don't stick out in your mind.
But here's the secret to this, right? So there are some that don't want to work with you, right? What you do is pick up the phone and call their supervisor saying, hey, I just had an interview with examiner X and this examiner has really not helped. This is our position. Can you take a look at it, right? And they'll take a look at it. And if the supervisor doesn't want to work with you, talk to the director. That's what we're there for.
That's good to hear. And I guess that's another question I had. Sometimes the examiner tells you, well, if you disagree with me, you can appeal. As a practitioner, how should you make the decision whether you should reach out to a supervisor, to the director, or whether you should file an appeal?
Well, first of all, you want to know that you're getting a fair shake, right? So if you feel like the examiner was being unreasonable and his position's off and it's going to be a waste of your time to appeal, go to the supervisor saying, hey, look, this is a really unreasonable position. You may not have a problem going to the board or appealing, but the examiner's wrong. And it can happen, right? And then supervisor will look at it. And if supervisor won't look at it, and if you feel like you're not getting a shake with the supervisor, come to us. But we only want you to appeal for cases that should be appealed. If something that we can resolve early, we'll do that. That's why we actually have a conference when, people appeal. And we look at it, we want to make sure that we're only sending cases up that merit an appeal.
And obviously sometimes appeals are necessary, but from an examiner standpoint, is that a negative outcome that it had to come to an appeal? Because obviously if every case got appealed, then, the PTO wouldn't really be able to operate.
I think it always goes back to I talk about interviews a lot. It really goes back to communication. It just depends on the type of communication the examiner and practitioner have been having up to that point. If you've had really good open communication, you both know your positions, and sometimes both parties dig their heels in saying, you know what, my position is correct, and you feel like your position is correct and you're not making any progress in amendments, then, that's the only option. But if you feel that, the examiner is way off, right, it's just totally unreasonable. Sometimes it's usually a difference of opinion, and then you just have a third party make a decision.
And maybe correct me if I'm wrong, from a standpoint of the applicant or a practitioner, if you're inflexible, then you're probably better off appealing. But if you're flexible and you want to figure out a way forward, then it probably makes sense to reach out to a supervisor and then the director.
Absolutely. And even when you're inflexible, if you feel examiner's position is totally off the mark, it's okay. I mean, if it's only like a little bit off, there's a difference of opinion, then chances are it's going to be hard for the supervisors to overrule the examiner. That's when there's really support their examiners. But if the examiner is in a different ballpark, then obviously you want to reach out to the supervisor.
That makes sense. Going back to what you said about searching and how you don't want piecemeal prosecution to happen, or one issue that you come across is that, and reasonably, a lot of times the examiners only search the claims. They don't search everything in the application. What is your view about that, and how should that really change as the prosecution goes along? Let's say you're after the first or second RCE. How should the examiner approach that case differently at that point?
So for me, the way I used to examine and preach when I was a supervisor, even as a director, right, claims is the last thing I like to look at because I want to search the invention. Because one of the things that I find to be really successful in the technologies that I've examined is that if you search the invention and you have a really solid prior art, it'll withstand any amendment.
Okay.
Right? That's what you want to be able to do. I want to be able to get the best prior art in the case.
Right.
So that's why we're developing some tools here within business methods to address some of those issues. I talk to the examiners. Sometimes I'll talk to the practitioners. There's one question I always ask both practitioners and examiners is the elevator pitch of your invention. What is this black box at the applicant invention? Can you describe that invention in one sentence or less? If you could do that, you have a good idea what the invention is, and you're going to be able to get the best prior art. Then you go to the claims. I used to call it the strainer method. If you put the invention in the strainer, you shake it, all those elements are coming out of those little holes. But if you just search the claims, imagine putting those elements through the strainer from the bottom up. What's easy?
Yeah, I think that's an awesome metaphor.
Yeah, so that's what I used when I was a SPE, and I still tend to use it, and it works for me.
and I guess, how do you encourage examiners to actually, is that still a challenge to get examiners to be thinking like that?
It is for some examiners, because some examiners feel that it takes too long to actually read the specs, so they have to search the claim because they have to reject the claim. So they think it's faster to search just the claims and be done with it. In reality, when they do that, it's actually taking them longer because they're doing a lot of rework. And then they're searching for something that they don't truly understand. They're spending hours searching. But if they had searched the invention, they would have been done a long time ago. And they would have understood some words that you guys are using that are different but mean the same thing. Now they've actually increased their knowledge by searching the invention, right? So sometimes it's just like a matter of selling it to them, saying, hey, for one case, try it. Don't look at the claims. Just search the invention and see what the results are.
Taking from that, I think it's really the responsibility of a practitioner to really provide a specification what will help the examiner easily understand what the invention is.
Here's what I've seen. I've seen some cases where the abstract is the first independent claim written in a sentence form.
Yeah.
Summary is the independent claim.
Yeah.
And background is 2 lines.
Right.
And then they describe the figures.
Right.
As a challenge for examiners to understand what the invention is.
Right.
So you're right. You have to write a good spec, a really good detailed spec, and really make sure that the abstract is really technical and describes the invention. And you want to make sure that the examiner is able to search and find the best part in the case because those are going to be your strongest patents.
Yeah, no, that's definitely a win-win situation, I guess.
Yes.
So going back to the fun stuff, the 101 stuff. Obviously, and going back to what we were saying, it shouldn't matter what art unit is examining a case. It should be examined in the same way. But should an examiner in the business method art unit really have a mindset of, I should probably give a 101 rejection? Should that be the mindset or not? Just because of a subject matter, is it fair for them?
I think that was probably a mindset a while ago. When Alice first came out, everyone was really unsure. And as you know, 4 years plus since Alice's decision, we're still struggling with some of the details of that decision and how to apply it. And I think the examiners were doing that. The bottom line is if the examiners are trained properly and they know how to make a decision, it shouldn't matter. The mindset shouldn't be that should I give an invention? Do you have the confidence in making a decision whether or not it's eligible? And that's why I tell them, if you feel like it's a gray area, just focus on prior art. I'd rather you not give it than give it. Give it only if you're confident, right? Because if you look at a rectangle, right? Look at 2 little slits on each side. Those are your definite areas. Everything else is in the middle. Those 2 little slits are definitely ineligible, definitely eligible. Everything else is gray area. If it's gray area, focus just on prior art.
And maybe you'll disagree with me, but I guess one of the issues that I see for step 2A of the analysis is that the examiner really has to figure out what the invention is about, what it's directed to, and then see if there's any court decision that says a similar concept was found to be not patentable under 101. In some ways, it's very hard to do because even practitioners, who knows all the decisions, who can think in a way to apply to each one, you'd have a whole litigation team kind of doing that kind of work. And then you're asking an examiner to do that. So one thing that I see is that examiners oftentimes try to just pigeonhole whatever your invention is into a court decision they're familiar with. Do you see that problem? How can examiners avoid doing that, I guess, besides just if it's in the gray area?
So you'll see it from a small subset of examiners who are still struggling with the 101 guidance. And they tend to do something that's comfortable. They've created a template that they're applying in every case. There are other examiners who really know the law, really understand the 101 guidance, and they won't do that. So the ones that are doing it and it doesn't fit, again, pick up the phone and call the supervisor saying, hey, I got this 101 rejection citing APG and it's not applicable. I mean, this is totally in left field. Could you take a look? And we'll do that. And I've done that multiple times.
Going back to that, about how much burden I think it is for an examiner, I a lot of times feel bad for them because I don't know if I could do this.
It is a lot, right? Because there's new decisions coming out all the time and they constantly have to stay on top of it, right? And that's why hopefully I'm sure you're going to ask me this later on, once the new guidance comes out, and that would help. And we have to wait and see for that. But hopefully it gives us a little bit more predictability and, reliability.
Yeah. And a little bit more about now for step 2B, because of a Berkheimer memorandum, the memorandum really puts the obligation on the examiner to go to each additional element and see whether it's well known or not. That seems like, they kind of have to almost do a secondary prior art analysis. And do you think that's a realistic burden for an examiner to actually go through that kind of analysis for each claim?
So what was happening before Berkheimer was examiners were using well-understood routine and conventional fairly loosely, right? They were saying, okay, it is, and some were backing it up. But if something is so well-understood and routine, you should be able to provide art. So somewhat similar to official notice, right? If something is so well-known and so routine, that you're able to reject a claim, well, just prove it. And I don't know if that's a huge burden because it's not the same level of test as prior art, because you're only citing a portion of that claim that they're citing as well understood, routine, and conventional. And so I don't think it's a huge burden. So if you want to use that, you should be able to back it up.
And obviously, and you touched upon that the new USPTO director said that he's going to come out with new guidance. So it seems that he's come to the conclusion that if the federal circuit is struggling with applying 101, then it's really not the best way to go in terms of making each examiner go through that. Can you tell us a little bit about more, any sense when the new guidelines will come out?
Our expectation is the new guidance should be coming out fairly soon. I think initially we were projecting sometimes in this first quarter of FY19. FY19 begin in October, so we're hoping very soon. I know that they have to go through some processes to get approvals, and once they do that, you will see some type of a Federal Register notice going out.
Do you have any sense about what the holdup is? Is it kind of digesting all these different decisions?
Since we're a government agency, I think we have various levels of approvals we have to go through for something like this. And I think it's just in the process.
For people or practitioners who are in this field, they're very optimistic about this guidance. Hearing Director Yanku talk about it, should examiners be approaching their work any differently in terms of anticipating that? From what I understand, the Director Yanku is saying that there's only certain particular areas that shouldn't be patentable under 101. It's not anything, you take anything and put up to an abstract level and say it should be rejected under 101. Should examiners be thinking about these issues differently because of that kind of?
Well, not at the moment. I mean, examiners need to apply the current guidance. Our current policy on 101 is still what's applicable. Until the new guidance comes out, they can't really apply it. So once the new guidance comes out, then they'll be expected to apply that.
I think you've given a lot of good advice to practitioners, but I wanted to talk about a few more specifics
Sure.
to get your insight. So let's say just a scenario, you get an office action, you look up the statistics about that examiner, and you find out that the examiner has examined a lot of applications, but he hasn't allowed a single case within the last, let's say, 2 years. How should a practitioner react to that? How should he approach that case? Should he handle it any differently than he would a different case?
So first of all, the statistics that you have may or may not be accurate. So they might be, right? You also have to look at a lot of other things. Sometimes there's examiners at different skill level. Brand new examiners probably will not have as many allowances versus a senior examiner. So it just depends on their grade level and where they are within the art unit. Second of all, if you as a practitioner have a case assigned with an examiner that you think doesn't allow, again, you want to judge or evaluate his decision-making as it pertains to you. So you receive an office action. If you think it's reasonable or if it's not reasonable, again, pick up the phone. Send a response in and point out why you disagree with them. Have an interview and talk about it. And you can always ask a supervisor to be present at the interview if you feel like that examiner is being unreasonable. So key thing is getting the supervisor in the loop. If the examiner is making a decision that's unreasonable, then you have an opportunity to discuss that with him and or with his supervisor.
And that makes sense. Try to get the supervisor involved early.
You need to, because like I said, we're here to help you. And sometimes the supervisor may be able to nudge or convince the examiner saying, hey, this claim is allowable or it's not applicable. This prior art is not applicable to those claims. So you want to open up those discussions. And most supervisors, when I talk to them, that's what they're doing.
And from a practitioner standpoint, and sometimes even the client standpoint, you don't want to bother the supervisor or the director until you at least feel you've done everything possible under the sun to deal with that examiner. Is that the right approach, or should you really be kind of proactive?
You need to be a little bit more proactive than that, right? There are probably two extremes. There's some folks, as soon as they get a first off session, they pick up the phone and call supervisors. Well, it's too soon. And some will wait for after 5 RCEs before they call a supervisor. Yeah. That's kind of late as well, right? There's a happy medium. So I think the best thing that you can do is after first off session, you feel like the examiner is way offline, pick up the phone, schedule an interview. Yeah. Again, like I talked about earlier, explain to the examiner what the invention is. I mean, what is your novel feature and how it relates to the actual inventive concept, and make sure the examiner understands it and let him know that his prior art is not applicable to the invention. And if he understands where you're coming from, hopefully he'll say, I agree with you. You know what? I need to update my search and see what else he finds. And if he doesn't, chances are you can get a positive result. Or he's going to find better prior art. Yeah. And either way, you're happy, right? So again, that communication is very important. Yeah. So you want to have that interview. Or if you have that interview and the examiner is being totally unreasonable, doesn't want to work with you, hey, maybe that's an opportunity for you to pick up the phone.
That's helpful. And sometimes I guess you gave very good advice about how to approach an interview. But let's say you're doing an interview and the examiner says, well, maybe you're right, but I can't come to an agreement. Is that a reasonable position for an examiner to take? When is it or it isn't? Is it reasonable for a practitioner to insist on reaching some kind of agreement?
So sure, and I know that's been a common question. First of all, it just depends on each interview, right? If the examiner says, you're right, get him to put it on the record, saying that, hey, the invention overcomes prior art, and then he needs to update his search. Yeah, there's no agreement on allowability, but there is an agreement that the current prior art is not applicable. But before you get there, you want to make sure that the examiner has signatory authority to make that decision. If you're talking to a junior examiner, he has no authority. So you want to make sure either a primary examiner is there with them or a supervisor so that they can make that determination. But you want to actually make sure that there is a follow-up after that interview on who's going to do what. So if you have follow-up action items for both sides, chances are you're going to make progress in the prosecution of your case.
And correct me if I'm wrong, but my understanding is if you really leave that interview not coming to an agreement, then there's a good chance you're not going to make progress.
You're probably right. It just depends on what it is, right?
Yeah.
Let's just say at the interview, both sides dig their heels in.
Right.
And both sides say, you know what, I'm right.
Yeah.
One thing that interview helped you with is you both know where your position is and it's not going to change.
Yeah.
Guess what? Time for an appeal.
Yeah.
Right? So, that's the only other option. But if you feel like the examiner is totally off base, being unreasonable, pick up the phone and call the supervisor, right?
And I guess from an examiner's standpoint, at least my sense is they're worried that they agree with you and then maybe they get your response or amendment back. They can never look at the prior art and they say, actually, it is in the prior art, Then they're like, I don't want them to hold it over me that I agreed and now I changed my mind. And that's why I don't want to come to an agreement. Should they have that concern?
Yes. So for me, my advice to examiners would be you always want to do the right thing. It's so easy to defend the right thing. And if I made a mistake, I can say, you know what? At the interview, I thought that my prior art didn't have it. But looking at it more now that I have more time, I was wrong. It's okay. Because I don't want you to issue a patent where prior art teaches the invention. I'd rather you reject it and say he was wrong than issue it to protect himself. And you wouldn't want that either. You don't want to have a patent that prior art's out there either, right? So I tell them it's okay to make mistakes. We're not perfect. We're going to make mistakes. But I want people to do the right thing, do a proper analysis, do a good job. And if we make a mistake because you did a good job, that's okay. We'll be able to defend it.
Because sometimes you discuss the case and you come to an agreement and it seems you have a positive resolution and then the holdup is really the wording of the agreement, the nature of the agreement. And it seems it's not allowed until you decide to allow the case.
Right.
Yeah.
And then you could point that out. I think some examiners are uncomfortable putting those words down on the interview summary form, but I think we just need to build confidence. And when examiners tend to do that, it's all about confidence. There's some examiners that are super confident in their prior art searching and super confident about what their position is. They're able to say anything that's appropriate, right? And the other examiners who are unsure, it's all about confidence.
Do you have any sense about what's most effective in terms of overcoming a one-on-one rejection? Is it a certain type of arguments? Is it certain type of amendments? Is it really looking towards certain core decisions, DDR, and so forth? What is your sense of where are applicants succeeding in changing examiners' minds?
So since I've been here in business methods, one of the things that I've seen is if something is eligible, we're going to find it. Because what we're doing is we're telling our examiners to be proactive. If you are going to make a one-on-one rejection, go into the spec. See if there's some subject matter we can bring out into the claims and suggest that. So we're using this proactive approach quite a bit. We have examiners who actually go to their supervisors. You know what? These claims are terrible. But the spec is really good. And what do you think if we recommend A, B, or C incorporated into these claims? Would that make the claims eligible? And then supervisor will look at it. A quas will look at it sometimes, right? It's like, oh yeah, let's do that. So we are really looking at a proactive approach. For practitioners, you got to follow the court decisions, right? So whether you look at Alice, DDR, or any of the other court decisions, if you feel like your claims are similar to some of the eligible court decisions, point that out. And we'll look at it. If somebody's having an unreasonable interpretation or position on your case, we'll take a look. Because at the end of the day, we want to help you get a patent, but we want to issue good patents.
So it seems from the practitioner standpoint, there's no magic bullet.
There really isn't a magic bullet.
They really need to look at the rejection. They really need to look at what their application is, and based on that, really figure out what the best kind of position is.
And I think one of the things that we touched on earlier is that if they're writing a new application, make sure there's a really good specification that explains the invention in technical terms, right? So we really need to understand what the invention is. Because if we're going to tell examiners to find the best prior art, they need to have a good specification that they could use to find best prior art and then reject the claims or allow them.
I was actually curious, you talked about what the role of a technology center director is, but I find the structure kind of interesting. Each technology center has 4 technology center directors, Director James Trammell, and you both are directors of the business method art units. how do you operate? Do you operate kind of as a team? Before anything, you talk to your supervisors, or is it kind of you're independent and then you just see where each other's at and kind of try to get the best?
Jim and I work together as a team. So we'll meet a couple times a week to address issues that's facing business methods. We have joint staff meetings. So we have staff meetings, both Jim and I are there. We basically do a lot of things together. We actually have individual conversations with our supervisors that are direct reports, but most of the things, most of the policies, most of the ways we implement our processes within business methods, it's like a team, as if we were just one person. And Jim and I actually go back a long way. We both became supervisors on the same day, believe it or not. We both were in the business methods arguments at SPEES.
Yeah.
And now we're both directors of business methods. So we go a long way, and we really know each other's strengths and weaknesses.
Right.
And we know each other's philosophies. Yeah. And we share a lot of things, that are similar. A lot of the things that I've talked about, he shares those as well.
Yeah. I imagine it makes maybe your job more fun.
Yeah. Like I said, I'm loving the job. I really have a lot of fun in business methods. You can see from my energy here, and you saw it when you saw me in Chicago. Yeah. I love this job. I love the organization. I think that USPTO has a really good model of like running an organization. It's a very performance-based, and I enjoy it.
That's great. Another thing that I missed, and we talked about interviews, but one of the programs that you helped implement was the FCP interview program.
Yes.
And if you look at the statistics that the PTO provides, it's kind of misleading. It seems that if you file an FCP, you have less of a chance to get an application allowed than if you don't file an FCP.
Correct.
Can you explain why that is? And
yeah. So it's really like there's actually two separate metrics, and it's apples and oranges, even though it looks the same, right? So if you look at the pure allowance rate of AFCP versus non-AFCP cases, non-AFCP cases has a higher allowance rate than AFCP cases. But the reason is, first of all, AFCP cases are self-selected. Second, the denominator in AFCP includes all the cases where the examiners chose not to consider under the pilot. So if you take those cases out of the denominator, then the AFCP cases have a higher allowance rate than the traditional. So really, you do have a higher allowance rate, even though those metrics say it doesn't, because the denominator is bigger.
Okay.
That's why. So, if examiner uses their professional judgment to consider the case under AFCP. So if you look at the cases where the examiner used their professional judgment and considered an AFCP 2.0 request only, right? Those allowance rates are higher than traditional after final filings.
Yeah. Is it a problem that you're seeing that examiners are just saying, nope, not enough time to consider
not enough time.
AFCP program? Is it a problem, or is it maybe they don't have enough time?
It's just a reality. You have to look at it. Some technologies have higher expectancy, so it takes a lot of time for the examiners to look at it. And then 2 or 3 hours is not enough for them.
Yeah.
Some other technologies, they don't. So if you compare a mechanical art to an electrical art, the expectancies are way off between the two.
Okay.
So the 2 hours in the electrical art is not as much as 2 hours in the mechanical art.
Right.
So the mechanical says, oh, yeah, SCP 2 hours. Oh, it's almost a count. I'm going to take it.
Okay.
Electrical is going to say, oh, my God, I'm barely going to scratch the surface on this. This is not enough.
It's my understanding that, I guess, one possible improvement to the FCP program is to really provide additional time based on what technology is being examined.
I think that's a good suggestion. We need to definitely look at that, and maybe that could be one improvement. Another improvement is there are some situations where examiner, if they felt like they could get another couple of hours on a case, they can allow it.
Yeah.
We tell examiners in those situations they can go to their supervisors and get that additional time. Yeah. We just didn't give a blanket time because we are already using so much non-production time for this free program. If there was a fee associated with it, it would be different.
Yeah.
But it's a free program, and it's costing the office hundreds of thousands of hours, and it's a challenge.
And I'm guessing a lot of practitioners and clients and applicants would be willing to pay some kind of fee if they actually get a full kind of examination at that point, than having to, file an RC. And even though sometimes it doesn't take that long, I think just mentally, it's kind of like once an examiner sees an RC and he's issuing a non-final office action, he's starting from the beginning, kind of.
True, and I think that's something that we have to look into, like some different options. But overall, I think the AFC program has been pretty successful. The fact that we've been able to move a lot of cases into allowance, whereas otherwise they would not have. Another thing that you want to look at with AFCP 2.0 is people who file AFCP 2.0 are less likely to go to the board than the people who file traditional after final. And right now, AFCP 2.0 is so popular, the number of filings for AFCP is higher than the traditional after final filings.
Yeah, I guess one of the benefits, even if a case isn't allowed, if the examiner is able to find good art during that searching process, then it gives you another opportunity to decide whether to further amend your claims or not.
True. And one other key feature of the program is that if the examiner does take time and they don't issue the case, they have to have the interview with you.
Yeah.
And that's been a big plus. And people will be able to make more progress that way.
Right. At least one more chance to convince the examiner to allow it.
There you go. Another bite at the apple, right?
Yeah. So I think the idea of the program is great. So,
okay, great. Thank you.
Before we are going to have two fun last questions, but before we get there, I guess a little more serious question. So it's a good thing and a bad thing, and it seems you disagree whether all these statistics about examiners are out there, but at least it gives you a sense of how different examiners really do truly operate differently.
Right.
From your viewpoint, maybe that's okay, or is that something that the PTO really needs to take a look at and kind of try to figure out? Maybe the examiner who's just allowing every case after the first office action, what is he doing during his examination? Or the examiner who's, requiring 2 RCUs for every case. Should the PTO be looking at those kind of pure statistics on the examiner level?
Yeah, I think we have looked at a lot of statistics. There's tons of data out there for us, right?
Yeah.
But one of the things that you have to remember is, innovation is very unique.
Yeah.
So every patent application is special and is very unique.
Yeah.
So you can't have a same standard on every single case.
Right. Yeah.
So you can't. You can apply consistent laws and procedures, but at the end of the day, each case is unique.
Right.
So we've looked at examiners where they've had very low allowances and very high allowances. And tell you the truth, out of the 8,000 examiners, that's a very small number.
Okay.
A very tiny number.
Yeah.
So most of the examiners are in the middle. Like when I talked about that rectangle with 2 slits and mostly gray area, well, those your 2 slits are a very small number of examiners that are not allowing very much, and there's a small number of examiners that are allowing just about everything.
Yeah.
Most of the folks are in the middle.
Yeah.
So it really, at the end of the day, you're going to get a fair shake. If you feel like the examiner is not issuing because that's just their philosophy, well, we can fix that. We can fix that, right?
Yeah.
Because their work is being reviewed by their supervisor, right?
Yeah.
Their work is being reviewed by Office of Patent Quality Assurance. So if somebody's doing a bad job, we find out and we fix it.
That's interesting because I always thought the quality control is once a case is allowed. That's at least no.
No, we look at it in all phases.
Okay.
So it's like, and allowances as well as non-allowances.
So sometimes there's feedback to an examiner, really, this has dragged on too long. Does that happen on an internal basis?
It's usually, we do some stuff internally looking at cases that have been pending for a very long time. Yeah. I do that a lot. But in terms of OPQA, they just look at an office action and they evaluate that office action. They don't really look at whether or not this has been pending for X number of years.
So they do look at, for example, an examiner applies a 101 rejection.
Right.
There are situations where the OPQA would say you shouldn't have applied a 101 rejection. Absolutely.
They'll do that. And they'll go both ways. Sometimes they'll say, you didn't give a 101, you should have. And sometimes they'll say, you gave a 101, you shouldn't have.
Last 2 questions. First question is, let's say there's a new examiner starting this year. What advice would you give him if he wants to become the next Tariq Hafiz?
Be innovative. That's what Tariq Hafiz is, right? I tend to innovate and try to figure out a different way of doing things. But ultimately, first, the new examiner needs to learn the job inside and out. Make sure he knows how to do it correctly. No shortcuts. And then after that, be innovative. Try different things.
It's interesting to hear you say that because you think, well, you're in a government bureaucracy, you're expected to do things a certain way. Did you really have that kind of latitude from the beginning to innovate?
Absolutely. There's innovation everywhere. You just have to go find it. So you can still do your processes, follow the policy, but you can still innovate. Whether you're in government or private sector, you have so much flexibility. You just have to open up and try different things. I try different things all the time, man. Some work and some don't. It's okay. I have no problems with failure, right? But at least I get to try it and enjoy trying different things. And my usually employees love it.
That's great to hear. Because the USPTO, at least, you always hear of new programs, new initiatives, and it seems everybody here is very open to kind of hearing what everybody thinks of practitioners. So it's kind
Believe it or not, like some of these programs, they come from our employees.
Okay.
Right?
Yeah.
They have a lot of ideas, and I want to hear from them.
The last question is, obviously, you love working here, and like you said, I really get the sense from you. But I think you would love working anywhere. At least that's my sense.
True.
But if you didn't end up working at the USPTO, is there any other career path that you think you might have liked to pursue?
That's a tough one. I don't know. When I came out of college, I was working for a defense contractor, and I was doing a lot of computer programming. If I didn't go up to PTO, I probably would have gotten into some type of a management position. I always wanted to manage folks.
Yeah.
So whether it was in the private sector or government, I probably would have been in management somewhere.
So I guess this works out great.
It worked out really well so far for me. I'm really happy here.
Everybody in America is lucky that you're here as well.
Thank you so much.
Thank you for joining us.
Really appreciate it.
Yeah.
All right,
Bye.
bye.